Hi, Attorney Steve Vondran. We are talking in this episode about BitTorrent lawsuits and can defendants recover their attorney fees if they successfully litigate a BitTorrent lawsuit. Okay, so we've talked so often about these torrent downloads. You know, this is good for your kids. If your kids are downloading movies, have these conversations with them. But essentially what happens if you're downloading movies from companies like Malibu Media or London Has Fallen, just for a couple examples, Dallas Buyers Club, so forth and so on. Actually, there's a lot of movies that are being tracked. But if your kids are downloading these movies, bear in mind the movie studios, the production companies, or their agents may be monitoring these torrent websites to try to catch somebody. And what happens once you get caught, they consider this to be copyright infringement. In other words, you're downloading movies, you're sharing them, and this is sort of how the swarm works in these torrent protocol cases. So in this episode, I'm talking about a Cobbler, Nevada case out of the district court in Oregon. And that was a case where a defendant challenged a torrent lawsuit in district court and basically said he filed a motion to dismiss under the Federal Rules of Civil Procedure, Section 12B. And basically, the defendant's story was, I didn't download this. I work at an adult group home, and it wasn't me. So in other words, it could have been anybody there. So he did not divulge the names. They eventually took his deposition, and they just said, you know, it wasn't me. So instead of just dismissing the case and working it out and being done with it, what happened is the plaintiff in that case, Cobbler, Nevada, went ahead and filed a motion to amend and basically naming the defendant in the lawsuit. So this created a big issue. Eventually, the plaintiff went and voluntarily dismissed the case. Now, that's something fine and dandy. Well, the defendant wasn't satisfied with that. The defendant said, well, look, if you're going to be dismissing your complaint, I want to seek my attorney fees. You know, there was no grounds to essentially bring this suit. And in copyright cases, defendants, a prevailing party defendant, can seek their attorney fees. And that's exactly what this defendant did, and to the tune of about $17,000. So this was not insubstantial. And we tell our clients, it can be costly to litigate, but if you definitely didn't do it, maybe there's a way, and I don't want to get people overexcited on recovering attorney fees. In this case, it was a recommendation, and I'm holding it in my hands here. This was a recommendation from the court to grant the attorney fee award. So I'm not sure how the case ended up. Lots of things can happen, but this was in the district court. This is case 3:15-CV00866. So you can look that up on Pacer Online, and that will help you find the case and read more about it if you're interested. So including there is a motion to dismiss in there, and this decision recommending attorney fee awards. So the court talked about basically, and this was a case with Comcast ISP, but the court talked about a prevailing defendant needing to show, and I'm going to read you some language. It says, the Copyright Act provides that attorney fee awards in copyright cases are discretionary. So the judge has the discretion whether or not to award a prevailing defendant attorney fees. And again, you have to be the prevailing party. Now that's the key, okay? And so the case talks a lot about what is a prevailing party. It says the key inquiry is whether some court action has created a material alteration of the legal relationship of the parties. So that's a lot of legal talk there. But it goes on to talk about a plaintiff's dismissal of a claim does not automatically confer prevailing party status upon the defendant. So in other words, just because they dismiss the case does not mean that you prevail. So the court's going to take a deeper look than just that, okay? It says, however, if a plaintiff is unable to refile the dismissed claim in federal court, the defendant is the prevailing party on the claim. So there's a lot of talk in here, but essentially with the 12B6 motion to dismiss, which we're going to talk about on another video separately from this, if you prevail on that, it could, and there's no grounds to refile, meaning they really don't have it. They can't properly allege that copyright infringement case, or in this case, as they talked about, contributory infringement, basically him contributing, the defendant contributing to, I suppose, some adults at the group home to download the movie, I suppose. So at any rate, so this is a really good case. It's promising for BitTorrent defendants. So if you need some help, if you find yourself involved in a BitTorrent lawsuit, or you received a notice of subpoena from your internet service provider, give us a call. We're happy to talk to you, tell you the pros and cons about challenging litigation, possibilities of settling your case anonymously before you're named in these lawsuits. A lot of times these suits are filed as John Doe lawsuits, and then the defendant's name is put in later if the case can't be settled. So we can help you try to get those cases settled anonymously. We can talk about defenses, possible mitigating factors. But for more information, you can go to our website, our tremendous BitTorrent Resource Center at copyrightbully.com. That's copyrightbully.com. Dirty Steve Vondran, I hope this has been helpful. I hope you've enjoyed it. And we will talk again. Have a great day. Thank you.